So let's move then on to the defences that may be available. And as I've said, this is not going to be a comprehensive analysis of all of these defences, because there are a whole multitude of defences, and they all depend on the particular circumstances as to whether they apply, and we just do not have time to go through them all. But I do think it's important to have somewhere sort of in your back of your mind, or I'd say written down, and I've certainly in the new Defending Possession Proceedings but tried to make sure that you do have a list of all of the types of defences that you can run, just so that even if none of them apply, you at least address your mind to whether they might apply, because there are so many. But the types of defences can largely be categorised into the 5 bullets on this slide, and the best type of defence is the first one, namely the lender does not have a right to possession, and what we've just been talking about now, whether a mortgage is enforceable or not, for example, would be the first type of defence. Mortgage not enforceable, therefore lender has no right to possession. But there may be other types of defences, which we'll look at in a moment, where the mortgage might be set aside, for example. The second category of defence is where there is a third party, so not the borrower, occupier, who has a better right to possession than the mortgagee. And that might be a tenant, it might be a spouse or civil partner, or some other occupier with an equitable interest in the land. The third type of defence, which is by far and away, say, the most common type of defence to any possession claim that you're likely to see, is that, okay, a possession order should be made, but it should be it should be postponed or suspended, or maybe even the claim should be adjourned in the instant, for various reasons, which we'll come on to look at. Fourth type of defence is you might be able to have it struck out. Unlikely, but you never know if it's procedurally defective, or you wouldn't be able to have it struck out for non-compliance with the mortgage arrears pre-action protocol, but you could probably have it adjourned or stayed or suspended. And then the final category is where, again, it's more of a link to the third bullet point, I suppose could also result in the right to possession not arising at all, is where the arrears are reduced or extinguished by a counterclaim or a defence to a claim that, for example, increased rates of interest or costs means that there are no arrears, or they're reduced to a point that enables the court to postpone or suspend an order for possession. Have a look at the first category of defence, and that's the no right to possession. And I'm not going to go through all of these, and we've already considered briefly that the first two, possession's not sought in good faith, that is an absolute defence, and we've also looked at the FISMA point. You may very rarely be able to argue that under the mortgage agreement there isn't a right to possession. It's likely to be rare, but there may be circumstances where the mortgage deed requires, say, the sum to be demanded or the sums outstanding to be called in. Nowadays, that's very unlikely. The fourth is the classic defence to a mortgage claim, which is that the mortgage is about to be or has been redeemed, i.e. it's been repaid, because once the mortgage has been repaid, that's effectively satisfying the equity of redemption, and the borrower then has the right to have the mortgage discharged. But most of the time, if the borrower has the money to pay the mortgage, there doesn't tend to be an issue, but that is a potential defence. Where you are arguing that the mortgage should be set aside for undue influence, that is a very good defence to utilise, and I will be considering that in a bit more detail subsequently. And sort of linked to undue influence, or species. They're not undue influence, but they're like undue influence. You can also have a mortgage set aside for unconscionable bargain or fraud or misrepresentation. We won't be considering those in more detail. Likewise, you have if, say, the mortgage has been forged or been non-eus factum, it's not my deed. Again, nowadays, it's almost impossible to run non-eus factum, and you'll need particularly strong facts to allege a forgery. If the mortgagee, the mortgagor lacked capacity to enter into the agreement, we'll be looking at that in a bit more detail later. If the mortgage broker was paid a secret commission, then that is a basis for setting aside the mortgage. We won't be, it's quite complicated, and we won't be looking at that in more detail, but there has been a recent Court of Appeal case called Wood, where that was considered in more detail. Again, for our purposes, it's unlikely to be of much assistance, which is why I'm not considering it in this webinar, because you have to give counter restitution. And most of the time, unless you're going to sell the property, most of our clients won't be in a position to give counter restitution, which is for the whole sum that's been advanced. But it can be useful for reducing costs and interest, because if the mortgage is set aside, then the additional rights to interest and costs are not going to apply. Limitation Act, again, it is possible, but almost unheard of. You may have a mortgagee that is stopped from bringing the claim for possession, and that's going to be very much on the case's own facts. It's likely to be where a mortgagee has promised to forbear on bringing a claim for possession, but it's worth knowing. But they're so fact specific and also pretty unlikely to arise. And then finally, the claim for possession amounts to unlawful discrimination under the Equality Act, which we will look at in slightly more detail, albeit, again, that is likely to be a rare defence that succeeds in knocking out the claim for possession entirely. I haven't included human rights on this slide for the reason that I cannot see how a human rights argument would now even be runnable. The case of McDonald and McDonald, which was decided under whether a defence, as I'm sure you all know, whether a defence to a Section 21 possession claim could be run with a Human Rights Act defence. And the Supreme Court said no. And the reason why the Supreme Court said no is because you couldn't use Human Rights Act defences to essentially disputes between two people arising under a contract, even if statute had intervened to regulate the contract. So, as you know, with a Section 21 claim, you have a tenancy, and whilst statute has intervened to set the parameters in which possession can be recovered, essentially it's a contract between two private individuals. And the same is equally true for mortgage possession proceedings. There's a contract between two individuals, and even though statute has intervened to regulate when possession can be recovered, you're going to be limited to running a gateway A challenge, i.e. you have to challenge the statute, the compatibility of the statute that is regulating the contractual relationship. And that's just not going to be a starter with mortgage possession proceedings, because there's old case law which says that Section 36 is compatible with the Human Rights Act. And the Consumer Credit Act 1974 gives the court more powers to intervene. So it's very unlikely that a challenge to the Consumer Credit Act as being incompatible with the Human Rights Act would succeed. Now, looking to the second category of defence, this is where you have the third party with a better right to possession, and it tends to be, well, I've split it into three types of occupier. You've got a tenant, be they authorised or unauthorised in possession, or an occupier with the benefit of home rights under the Family Law Act, or an occupier with the benefit of an equitable interest that binds a mortgagee. And we'll look at 3 and 4 in more detail later on. Just before we move on, though, I do just briefly address the issue of tenants, because it's probably quite common for tenants of borrowers to turn up to on a duty desk where they've been serving proceedings by the lender, and they want to try and defend the claim. Generally speaking, most tenants will be unauthorised tenants, because even if you've got a buy-to-let mortgage which expressly authorises tenancies to be granted, strictly speaking, they don't bind mortgagees unless you have a very unusual mortgage deed, and therefore the mortgagee will have a right of possession against the tenant. It's only likely for you to have a decent defence if you are a tenant of a borrower who has subsequently remortgaged. So, for example, the borrower grants a tenancy to a tenant of the property and then takes out their second charge against the property. The holder of the second charge, the mortgagee of the second charge, will not have a right of possession against the tenant that was already in situ. Even where you do have unauthorised tenants, the court does have power to postpone the date for possession for a period of not exceeding 2 months. And when it comes to the warrant coming to be executed, again, provided the court hasn't previously postponed the possession order, then the court has the power to suspend a warrant for possession, and that's under the Mortgage Repossessions Protection of Tenants Act 2010. And so whilst I didn't say this was a key resource, it's probably also a useful act to have to hand, even if you do have the Defending Possession Proceedings review on the day. It's checking, because mortgagees are also required to have given notice of the claim, of enforcing the warrant of possession under the Act, and sometimes they don't do that. So it's a useful act to have with you on the day. Then, as I said earlier, the most common types of defences, which aren't really defences, but essentially the court's power to postpone or suspend possession, which I'm going to look at in more detail in a moment. You may have other procedural defences, which are set out on this slide, which I'm not going to go through in any great detail, but they're set out at length in Defending Possession Proceedings. And then finally, as I say, there may be a counterclaim or a defence to increase interest or cost provisions, which might result in the arrears being reduced so as to either extinguish them entirely, unlikely, or at least reduce them to an extent which means it's easier to convince the court to suspend or postpone a date for possession. Right, so we're now going to move on to look at some of the defences in more detail. And the first that we're going to look at are time orders. And I've expressed this section's time orders or section 36, because this is one of the key changes that have been made by bringing most mortgages into the, let me rephrase that, giving the courts power under Part 9 in respect of most mortgages of dwellings and residential property, because the powers under the Consumer Credit Act are more extensive than those that the court has under Section 36. But the courts have been used to dealing with Section 36 since the 70s, and that the court really needs to be reminded of the new powers that they have, which they may not be aware of. So, as I've already said, Part 9 of the Consumer Credit Act applies to regulated mortgage contracts and regulated agreements, albeit the unfair credit relationship provisions do not apply to regulated mortgage contracts. What are the powers under Part 9? Well, under Section 129, it's the power to make a time order. There is a freestanding power to suspend an order for possession, albeit they're most likely to be combined with making a time order. There's a provision as to unfair relationships, which I'm not going to look at because, as I say, it doesn't apply to regulated mortgage contracts. But one of the best powers that the court has is under Section 134, which is when it's making a time order, it also has the power to amend any agreement or security, and that may involve changing the rate of interest, changing the number of payments, and so that's a very powerful tool at the court's disposal, which goes without saying, such powers do not exist under Section 36 of the Administration of Justice Act. So when the court makes a time order, it may provide for one or both of the following things. The payment by the borrower of any sum owed under the mortgage by such instalments payable at such time as the court, having regard to the means of the borrower, considers reasonable. It also has the power, when making order, for the remedying by the borrower of a regulated agreement or regulated mortgage contract other than non-payment of money within such period as the court may specify. And the sum owed helpfully means the total indebtedness, not just the arrears that are owed. So this gives the court a particularly wide power because it essentially has the power to change the instalments and when the payments are to be made and the amounts of the payments, having regard to the means of the borrower. So potentially a very wide power indeed. Now, you won't be surprised that there is some fetter on this discretion, and Section 129 makes it clear that a making of a time order can only be made if it appears to the court just to do so. And again, you won't be surprised that the Court of Appeal and House of Lords has considered what just to do so means in particular circumstances and how the court should exercise its discretion. And it's been held that while Section 129 expressly directs the court to the borrower's circumstances, the court also has to consider the lender's position. Surprise, surprise. And so a time order, it's been held in the Southern and District Finance and Barnes case, should normally only be made on account of the borrower's temporary financial difficulty. So if you have a borrower who is in a very poor financial state and has always struggled to pay the mortgage and can provide little evidence to the court that they're ever likely to repay the total amount loaned, then the court is not going to make a time order based on the borrower's circumstances, such as paying £50 a month, say, when the monthly instalments are £1,000 a month. Even if that's what the borrower can afford, the court's just not going to make a time order in those circumstances. And the House of Lords has also held that the second to last bullet point on this slide, that time orders extending over long periods of time are usually better avoided, but in an appropriate case, it has been held that it is possible for monthly instalments to be reduced and the term extended, provided it's just to do so. So whilst generally speaking, if you have a borrower that is in a perilous state, you're not going to be in any better position as you were under Section 36. There are exceptions, and the crucial point here is that there is no jurisdictional requirement that the arrears be cleared within a reasonable period, as was the case, or is the case more accurately, under Section 36. And I've set out on this slide what it is possible for a court to do when making a time order. So first of all, court could extend the term and spread out the monthly payments. And I would submit that could do that even once the term was ended, provided that there was good evidence that this would mean that the borrower would be able to repay the sum. And especially if you're faced by a claim by a high street bank, which quite frankly is not going to be overly prejudiced by the term being extended, provided they're going to get their money and they get their interest. But it will depend on the circumstances, and you're going to have pretty good evidence to show that the borrower can pay the reduced payments over an extended period of time. But the best example might be where a mortgage has been taken out, probably would have to be by someone who's relatively young. And at the time that they took the mortgage out, they were earning a certain amount of money, and they've since got a different job which pays them slightly less, which means that whilst they're good for the money in the long run, they just can't afford the current monthly instalments. They need to pay less. The other option is the deferring of capital, so effectively turning the mortgage into an interest-only mortgage for a short period of time. And that might be, again, because there's a short period of time in which the borrower is simply unable to make the monthly instalments, but in the long run, they will be able to. The other power is to amend the rate of interest, and this is the thing which always attracted quite a lot of interest or attention. But the courts are quite reluctant to do this, except for in very particular circumstances. And it tends to be where you already have a high rate of interest, which is because the high rate of interest is to factor in a degree of risk, maybe to do with the borrower or the type of loan that has been taken out. And the argument is that if you've already got a high rate of interest to factor in a risk, if the term is being extended and the sum is still going to be paid, there's no reason why the borrower should end up paying more interest if the lender is actually going to get the money that they advance, because the risk is not there. But you'll see why such powers are not likely to be utilised often, because you'll have to show that there isn't the risk of the lender losing the money, and also with the more mainstream banks that are lending at very low rates of interest these days, if you've extended the date of the time for repaying the capital, it's hardly really, the court's not going to think it just to reduce the rate of interest, and they're going to find it's very unjust to reduce the rate of interest if the borrower is having to pay back the capital sum over a greater or a longer period. The court may also adjourn or suspend the enforcement of a possession order on terms that essentially comply with the time order. So the mortgagee can't come back to court so long as the time order is complied with. Now, Section 36 still applies. It also applies to unregulated agreements. So if the mortgage is not a regulated mortgage contract or it's not a regulated agreement, then you can still resort back to Section 36. But as I've said, I think if you have a regulated mortgage contract, there really is no reason to go to Section 36 because it doesn't do anything that time orders can't do. There is a general power to suspend anyway under the Consumer Credit Act, which normally will be coupled with a time order, but there may be circumstances in which the court does decide to adjourn or suspend execution of a possession order, even if not making a time order. And you just don't have to get over the jurisdictional threshold in Section 36 of the arrears having to be repaid within a reasonable period. So provided you have a regulated mortgage contract or a regulated agreement, you really shouldn't having to be resorting to Section 36 again. Just briefly want to focus on the pre-action protocol before moving on. That the pre-action protocol does not alter the parties' rights and obligations. So you may say, well, what use is it at all? Because if the lender doesn't comply with the mortgage pre-action protocol and comes to court and asks for a possession order and is entitled to a possession order, the failure to comply with the protocol won't stop the court from making an order. But that's not right, because if the court does have jurisdiction under the Consumer Credit Act 1974 or the Administration of Justice Act, if they apply, not to make a possession order. And the editorial notes in the White Book make it clear that one of the, or three of the consequences arising from non-compliance with the protocol, provided that the court has the jurisdiction to adjourn or suspend under the Consumer Credit Act, are that the claim should be adjourned. And I think the use of the protocol where it hasn't been complied with is quite a useful tool in buying a bit more time, so that you can make sure that you consider in detail a proper defence. And so definitely something to be considered, even if on its face it seems like the pre-action protocol lacks teeth. So third-party interests that bind a mortgagee. So I think we've already considered earlier. The circumstances to look out for are those on this slide. You're looking for the tenancies that generally predate the mortgage. But beyond tenancies, the most likely types of situations are where you may have a trust, whether it's express or constructive, whereby a third party has a beneficial interest in the property. They may have a proprietary estoppel, which gives them a right to a proprietary right in the property, and their interests that bind the mortgagee. So they essentially have a better right to possession than the mortgagee, and we'll look at those in a bit more detail later. There is also where you have a spouse or civil partner with home rights under the Family Law Act 1996, which also bind the mortgagee. Now, where you have a trust interest, so you have a beneficial interest under a trust, it's almost certain that won't be protected on the land register, because trust interest cannot be protected by a notice. It's one of the key features of the Land Registration Act. But you do have what you're probably familiar with are overriding interests in respect of registered land, which still bind the mortgagee even if they aren't noted on the register. Now, a tenancy of less than 7 years does not need to be registered. So provided it was granted before the mortgage was granted by the lender, then that tenancy will bind the mortgagee. But the other type of interest that's most likely to be of assistance is where the third party has an interest in land and that person is in actual occupation of the land. So you may have, say, a partner, cohabiting partner, who has paid towards the acquisition of the property, and for whatever reason they aren't the legal owner of the property. In those circumstances, they're likely to have an extra interest by way of a constructive trust. And I haven't mentioned it in the notes, but the relevant cases to have a look at in those circumstances are Stack and Dowden and Jones and Kernet. So they, if you're going to be doing this area in detail and seek to specialise in this area, I strongly recommend reading Stack and Dowden and Kernet and Jones. But say you think you've got a beneficial interest under a constructive trust, that's not enough. First of all, you have to be an actual occupation, which if you're living in the property, well, that's pretty easy to establish. But it will only apply if and it's slightly, I always find this difficult because the Land Registration Act, the way it's drafted, the way it's phrased is like in the reverse. So it's in the, you have an interest in land that's held by a person in actual occupation unless their interest is undisclosed following an inquiry by the mortgagee. So if the interest is disclosed, then they're in actual occupation. But if the interest is disclosed, it's very unlikely that the mortgagee will have granted the mortgage without at least having the occupier postpone, fill in a form postponing their interest so that the mortgage takes priority. So very unlikely that if that bullet is going to apply if there was actually an inquiry made. And then it would also, there'll be an overriding interest unless it would not have been obvious on a reasonably careful inspection of the land at the time of the mortgage and the mortgagee lacks knowledge of the interest. So if the mortgagee had attended the property and the fact that the person with this interest was living in actual occupation, if that would have been obvious, then that person has an overriding interest. If their occupation is not obvious, then the mortgagee is able to escape the overriding interest. So that is the situation in which most of these arise, is that if someone's living there and the mortgagee hasn't carried out the proper due diligence, then they're likely to be bound by the overriding interest. Final point to note is that the interest, it must be an interest in land, so a proprietary right. A license to occupy, for example, is not a proprietary right. So you do generally need a trust interest or an interest under a proprietary estoppel. For anybody who don't have time to go through what is a proprietary estoppel or the types of circumstances in which an extra interest under a constructive trust arises, but those are the most common situations in which you can use the overriding interest provisions. The next situation is where a spouse or civil partner has home rights, and that will arise, they'll have home rights if their spouse or civil partner has the right to occupy a dwelling by virtue of a beneficial estate or interest or contract or any enactment, and they do not. So in short, you've got one person in the relationship. Historically, and I'm trying not to do this, but historically it would have been the husband, the legal owner, but it obviously doesn't have to be. But you have one person who's the legal owner, and then the spouse or civil partner doesn't have aren't the joint legal owner, and they don't have their own interest. They will have home rights, and those rights are capable of binding mortgagees if they are registered by notice. But they cannot be overriding interest. And what this means is that whilst every spouse or civil partner will have home rights if they don't have any other proprietary right to stay in the home, unless they've been protected by notice, then the mortgagee can take free of them. And so what you essentially need to have is a spouse or civil partner that is very distrusting of their other half, because they've decided, they're concerned that they're going to mortgage the property without their knowledge, so as to put their rights to occupy the family home at risk. So it's not that common for home rights to be registered. And often they're registered after the event, because it's the very fact that they've learned that the property has been mortgaged which causes them to have some concern. But by then it's too late. But it is a potential and to bind mortgagees.